Hello ladies and gentlemen, welcome back to this channel. In this video I'm talking about privity of contract. I'm explaining what is privity of contract and what are the exceptions to this principle of contract privity. The word privity means party to. So this video is really about being a party to a contract or not being a party to a contract. So the doctrine of privity states that if you are not party to the contract, you cannot enforce that contract. You have no business suing on that contract. So even if you are a beneficiary to the contract, the general rule is that if you are not party to it, you are not part of the original parties, you are not entitled to sue on that contract. So privy means you're not party to, you're not involved in, you're excluded, you're not party to enforcement of that contract. Now, this case Dunlop versus Selvage is a leading case on this matter. It's the one that established this principle mainly. There are some cases before it, but this is a landmark case on this matter. And in this case, the plaintiff sold tires to Duke Company, and Duke Company agreed not to sell the tires below a certain price that they provided. So these guys were selling tires and they were supposed to sell them on the according to the price that was listed, their pricing method. And they were supposed to tell everyone they sold the tires to that if you're selling those tires, don't sell them below this particular price. Now, Dew and Company sold the tires to Selfridge, and they agreed with Selfridge that they would not sell the goods below the provided price. Selfridge, however, breached this agreement and sold the tires at a lower price. So Dunlop sued Selfridge, saying that you're breaching our price agreement of selling tires if you're selling our tires. Court observed that Dunlop could not insist on that contract on Selfridge because the contract was between Dunlop and Duke Company. Selfridge was not a party to that price contract that they had. So court observed that the plaintiff had no right of action, Dunlop had no right of action, or Dunlop could not sue because he did not give any consideration to Selfridge so as to force Selfridge to stand by the price requirements. So in this case, it's established that if you're not party to the original contract, you cannot enforce that contract with any other subsequent parties. So the doctrine of privity has some exceptions, about 6 exceptions, which we are going to look at. And the first exception is agency. With the principle of agency, we are saying that even if you're not part of the contract between the principal and whoever he signed with, if you're the principal's agent, the law can enforce the contract against you. That's how you find that all these people who sell things on behalf of companies who come to your hostel saying, oh, I belong to this company, I'm selling these things, all those are agents, mercantile agents, but those agents, the law can enforce a contract against them because they represent their principal. The agent represents the principal. So you find that the doctrine of privity does not hold water with respect to the agents, because even if the agents are not the one that signed the original contract and it was signed by their principal, the law will enforce the contract against the agent, because in agency, an agent reacts or works on behalf of the principal. Now, with respect to a bill of exchange, examples of bill exchanges are like checks. You'll find that even if you're not the one who was, even if the check was not written out to you originally, where it was just signed off and transferred to you, you can sue that person who's the signatory to that check because of the principle of, because of the exception of bills of exchange to the doctrine of privity. In other words, you are not privy or you are not party to the original agreement and the original check which was written to someone, and therefore you cannot sue. But because it is a doctrine, it's a bill of exchange, because it is a check, the law gives an exception to allow you to sue the person on the check, the signatory on the check, in case that money bounces, for example, in case a check bounces. Because even if you're not party to the original signatures and the deal between the original signatures, as long as it's transferred to you, you're entitled to sue on that check. The third exception is respect to assignment, and by assignment here we're saying someone signs off their rights to you. For example, maybe they are they own property or shares in the company, and they decide to sign off their share interest to you, the law says that because you have the right of assignment, someone has assigned their right to you, you are entitled to sue on that right, even if originally you are not party to that deal, you are not party to that contract. So the doctrine of privity won't work on you by respect of the fact that what you're handling is an assignment. So if you can prove that under a contract, the contract was assigned to you or was transferred to you, even if you are not originally part of the people who signed the contract, the fact that you have the rights of transfer in that contract, it allows you in law to be able to sue on that contract. Now, with respect to the law of trusts, you find that where there is a trust and a beneficiary or someone who's benefiting from this trust property can sue the trustee if the trustee is misusing the land or the property, even if the beneficiary was not part to the original, trust deeds and all those things. So the beneficiary acquires a right to sue the trustee if the trustee is interfering with the trust and misappropriating the funds. And you see that that's another exception with respect to the doctrine of privity, whereby if it affects a trustee, a beneficiary, and even if the beneficiary is not part of the original, deal and the original trusteeship, but they're entitled to sue because they are the beneficiary by virtue of the fact that they are the beneficiary to the trust. So number 5, exception. Usually there are some statutory or statutes that allow exceptions. For example, insurance contracts. You'll find that you're not party to the insurance itself, even if it's a third-party insurance. The third party is between the car owner and maybe the insurance company. But if you're knocked in that car, you're entitled to sue and claim the payment from the insurance company, even though you're not party to the contract, by virtue of the fact that the law provides for that kind of provision in the insurance contracts. Restrictive covenants, on the other hand, are covenants are agreements that pass with the land. You would find that, for example, if we have the city square in Uganda, they would say that no one should put a building on the city square, and that's a covenant or a restriction on that land that will survive all the years to come. So the law says that those kind of restrictive covenants can stand and anyone can enforce them even if they were not party to the contract. Anyone who has the right to sue or who would like to sue can enforce the restrictive covenant even if they were not party to the original covenant that established it. So these are the principles of the exceptions to the doctrine of privity. I've really kept it simple so that you understand it easily. But just remember that doctrine of privity means the doctrine of being a party to a contract. Generally speaking, if you're not party to a contract, you cannot enforce that contract. You have no right to be heard on that contract, except in some of the provisions that we've seen: insurance, restrictive covenant. We've also talked about agency, checks. There are certain exceptions whereby they say, okay, in those instances, you can sue even if you are not party to the covenant. But automatically, and the main principle is that if you're not party to a covenant, if you're not party to a contract, you cannot enforce that contract because you did not furnish consideration. If you have not furnished consideration, you cannot enforce a contract.